And so we're going to go through all of the emotions of all of these motions.
Now, some forensic evidence disputes is shaping up to be a battle of the experts. The defense and the prosecution will likely present, once again, competing forensic analyses at the trial, and the jury's going to have to weigh which narrative they find more credible. This could be a turning point in the case, as forensic evidence often carries very significant weight with jurors. Jurors believe that such evidence, and jurors are going to render a decision in accordance with what they hear.
I'm just saying that this is getting worse day by day. I don't know what to think. I come from a very high trust country. I do layman duty, that's jury duty, a lot. I have never, ever seen anything this bad.
But the judge said, if we don't have the evidentiary hearing in this situation, do we really need 2 days of hearings this week, Thursday and Friday? And everybody agreed no. So now that there's no hearing, we've got more time to handle other things.
The defense's allegations of witness tampering could further complicate matters and may lead to additional investigations or further motions.
By Wednesday next week, February 5th, the prosecution must turn over all evidence to the defense.
How do you know what hasn't been turned over if you don't have record of it?
I anticipate, since they're supposed to get the final discovery on Wednesday, and who knows, that very well could come after working hours, but even if it came before, there's no way they're going to get through all of it.
Don't know what's wrong, but reading motions like this where he willfully or mistakenly misrepresents basic facts in the case, basic legal arguments, it's disheartening to see.
And stuff is heating up because we're what? February, March, 2 full months away from this trial starting. I can't believe it. I can't believe it. It feels like there's so much that still needs to happen with the new team.
The defense has been ordered to file their motion to dismiss by February 11th. By February 14th, Valentine's Day, the Commonwealth must respond to that motion to dismiss. They are going to make a motion to dismiss for extraordinary governmental misconduct.
And then what she's talking about, there's an anticipatory motion to dismiss coming from the defense. And now she's setting that for the following week, not next week, but the week after, for a full hearing on that. That'll be good.
The defense was disinclined to acquiesce to that request and said, we need more time to file our motion to dismiss. We will be filing a motion to dismiss, but it will not be filed before Thursday. The court said, be prepared to discuss it.
The judge also said, hey, defense team, you guys mentioned a motion to dismiss. Can you please go ahead and file that motion to dismiss by Friday? And the defense is like, no, judge, we've got all this crap going on, especially with all these new Daubert motions. We can't file it by Friday.
The arguments raised in the motion could set the stage for critical pretrial rulings, as well as appeal in the unlikely event of a conviction.
February 18th, there will be a hearing on the motion to dismiss.
Now, unfortunately, you and I both know that Antibev is never going to rule in the defense's favor on such motions, but they have to do it anyway. They have to try. They have to preserve the record on appeal.
February 21st is the drop-dead date for the filing of all evidentiary motions.
Unless most of it has already been sent. That's what I'm not sure how much more is coming. But if it's a lot more, like a lot more emails and things like that, you might hear the defense saying, look, Your Honor, I know you said you want this by Tuesday, but I'm telling you, we're not going to get through all of this discovery.
Prosecution said, look, I went back through, this is the new special prosecutor, Brennan. I went back through and bait stamped everything to make sure that everything that we thought had been turned over, everything new has been turned over, and we have a way to keep track of it, which wasn't done before. And I was like, what?
Now, with respect to discovery, if the defense's claims about withheld evidence are substantiated, it could also open the door to sanctions against the prosecution or even a mistrial. Courts take discovery violations very seriously, as they can undermine the fairness of the trial. For example, see what happened with the Alec Baldwin case in July last year.
I'm waiting to see the motions to dismiss and the response to see how much of an issue that is, but it's an issue. Things should be turned over. And there shouldn't be a guessing game over whether or not you have all of the discovery.
This is potential Brady evidence. It's potential exculpatory evidence. The prosecution is legally required to preserve and disclose this. 2 years later, they are now making the claims that don't even hold up to basic scrutiny.
And I think what she'll say is file what on all the issues that you know as of now and are ready. And if you need to supplement later as you review discovery, then we'll take it up, at that point. But she's going to want at least what they have been, thinking about placed into a writing and on the record, by that Tuesday.
At the minimum, what should be done and should have been done before the first trial, and we've seen the defense note in several motions that things were just not turned over to them. And no matter what you think of this case, no matter what you think of the lawyers, their arguments, the judge, or any of it, at a minimum, there should be zero hide the ball in criminal court. Everything should be turned over. And it's clear from the motions that there are things that had not been turned over in a timely fashion, and that is an issue.
The Commonwealth opposed paying the expert fees. I want to read that motion. I haven't read it yet, but I wonder if they just oppose like that you should dismiss the case, or that they did it on purpose, but they actually are going to pay the fees, because we've had cases where the defense is like, yeah, we screwed up. We're going to pay the expert fees.
That is the motion where the defense said, Your Honor, we sent our expert all the way to Massachusetts to download the original data off of the Canton Police Department DVR system that governs all of the motion activated cameras around the police station. And lo and behold, when we got there, there was no original data on the DVR.
I'm still of the mind that if you had a really just straight by the book judge in this case, she would have laughed at him, thrown this motion back in his face, and said, produce the evidence with the metadata. He can't even guarantee that they can get the evidence. He doesn't know if it exists. If you have given it to the defense, of course you have a copy, because you are legally obliged to keep Brady evidence.
They're opposing it. So were there some factual inaccuracies on the defense? Are they going to say there was from the defense side? I don't know. I want to see this.
So our expert flew to Massachusetts and spent their time at Canton PD trying to get information out of the system. And there were no logs. There was no original data. And they refused to provide us with anything. They said it's already been provided to the defense.
Why don't they already have all the videos with the metadata? Is it because they don't know the facts of the case? Is it they are misrepresenting the facts? I don't know.
But then there's no metadata left with regard to that video. So the defense has said, we can't ascertain how this shit got flipped, why there are timestamps missing, because we can't see when the activation of the motion capture was activated on, activated off, how the system was working. We can't see the logs of who accessed the system and when. And we wasted our experts' time, and the defendant should not have to bear that expense when the Commonwealth told us, yeah, your expert can come out and get this information. And because you did not tell us accurately that that information was gone, we wasted our time and money.
Something about March 4th and 5th evidentiary hearings. I'm not sure if those are the motions in lemonade, as we call them.
The Commonwealth indicated that they have a new accident reconstructionist, that there is a neurologist that they are waiting on a report for, that there was a new witness interview, and that there's a new report from their digital expert, Hyde, and that there is another report regarding a different cell phone. So there is still more information being given from the prosecution to the defense going on into next week. So the defense said, until we have all their information, we can't do our work until they do their work, and they're getting it to us on Wednesday. And then we need that information to go forward and finish our work, our motion to dismiss, the motions in limine, any motions to suppress.
This case should be dismissed with a vengeance. Karen Read should be set free.
District attorney went off the rails. innocent until proven guilty. Never came out of his mouth. That is outrageous. We are outraged. Before any trial has occurred, he announced the defendant's theory of the case is a desperate attempt to reassign guilt. That is outrageous. We are outraged. He provided a false notice of discovery, claiming he did not know. We now know that was a lie. That is outrageous. We are outraged. This court should be outraged. Everyone should be outraged. That is outrageous. We are outraged. District attorney went off the rails. Innocent until proven guilty. Never came out of his mouth. That is outrageous. We are outraged.